During closing arguments, can I ridicule the defense's arguments? You want to know the answer? Come join me on this walk as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is yes, I can. Now, take a look where I'm shooting video. I'm actually on a deserted island here in St. Martin on the French side. My wife comes here to pick seashells, and I have a few minutes to share this great information with you. All right, so let's get back to the question I raised in the title of this video. Your medical malpractice case is on trial. Now we've reached the end of your trial, and now it's time for closing arguments. The defense goes first in making their closing arguments, and now I get up to make my closing arguments. Can I ridicule the defense's arguments to show the jury that what they're saying makes no sense? To show the jury that it's illogical what they're claiming? The answer is yes, I can. But think about this. Wouldn't it be a better strategy for me to spend the time that I have to talk to the jury about our best arguments, about our reasons why we believe the doctor violated the basic standards of medical care, causing you significant harm and injury? The answer is yes, it would. So why would I spend the time to actually ridicule the defense's arguments? Reality is you'll find that the best trial attorneys actually do both. But I don't want to spend a significant amount of time focusing on the defense's arguments because they may bait me. They may do it solely to try and get me to respond to their arguments and raise unanswered questions during their argument, hoping that I will now take the time to respond to their argument. And you know what? That means I'm taking the bait, which means I'm taking away good, valuable time that I could use to focus on our strong points rather than focusing on the defense's arguments and my reply to that. You'll find that the best attorneys actually do both. So, I will put forth our best arguments, explaining why we believe we're entitled to a verdict in our favor and why the defense's argument is ridiculous, why it's illogical, why it makes no sense whatsoever. And then I'll quickly focus on our arguments. And this way, I don't want the jury to recognize that I'm spending an inordinate amount of time responding to the defense's arguments, and they might be thinking if I do that, hey, why is he spending so much time arguing against the defense's arguments? Shouldn't he be arguing about his own client's arguments and about his experts' opinions? The answer is yes, I should. That's one of the key reasons why we will go ahead and, yes, point out to the jury why the defense's arguments are incorrect, but not spend much time on it at all. Instead, I want the jury to focus on our arguments, on why we believe we're entitled to a verdict in our favor. So why do I share this quick information with you? I share it with you just to give you a beautiful view of the scenery, but in addition, I wanted you to see what goes on behind the scenes in these medical malpractice cases. You know, I do recognize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit and are thinking of doing so, but still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. Well, I'm going to go find my wife who's picking shelves now. I'm Gerry Oginski. Have a great day.